Good afternoon, Chief Justice, and good afternoon, Commissioners.
How are you?
I'm well, Chief Justice, and you?
I'm fine, thanks. You are from my neck of the woods. You come from the Eastern Cape,
Of course, Chief Justice.
and you studied at my alma mater, the University of Transkei,
Of course, I am from UNITRA.
where you obtained 2 degrees, a B.Juris and LLB.
Yes.
Did you proceed to work there? Your CV says you worked as a legal assistant at the Lawyers for Human Rights. Where was that?
If I may start by saying, when I first went to University of Transkei, there was an Office of Lawyers for Human Rights that was at, I can't remember the street name.
In Mthatha?
In Mthatha. It was headed by Ms. Dennis Rudolph at that time. So Ms. Dennis Rudolph used to go to the University of Transkei to educate or train students about what human rights are for. So I then cultivated a relationship with that office, and I still remember in my very first year, I asked Ms. Rudolph whether I could come to the office and do voluntary work during school holidays, because I was interested in the human rights law.
Then you were a regional distribution coordinator with the Independent Forum for Electoral Education.
Yes.
What did you do there?
It was during the time when we were preparing for the first democratic election in South Africa. So Lawyers for Human Rights had so many projects at that time. So we were busy with voter education as students. We were busy with so many things under the umbrella of Lawyers for Human Rights. So I was busy with voter education for almost every magisterial district of Transkei. I traveled Transkei throughout. That is building up to the general election in 1994.
All right. Then you were a legal advisor at Madikizela and Associates, but
yes,
for a very brief spell.
I liked doing vocational work. Even then also, I wanted to gain some experience in litigation. I would ask the directors that, can I come to your office and do some voluntary work? Mostly I got into those offices by doing voluntary work, but by the time the time comes for me to leave and go back to university, I would get some stipend or something. Yeah.
Then you returned to Lawyers for Human Rights for
I built
years.
a very solid relationship with the Lawyers for Human Rights, because that's where I started. That's where I cut my teeth as a lawyer. That's where I was told that a lawyer never writes with a blue pen. A lawyer uses a black pen to write.
And you just decided that you were going to join the sidebar, and you went and did your articles and started practicing.
Yes, definitely, at GLIACO Incorporated at Owen Street.
You worked for a number of firms, including the Women's Legal Center. Where was that?
In Cape Town.
In Cape Town.
Yes.
And joined the State Attorney's Office.
Yes.
As a senior assistant state attorney.
I started as an assistant, then I was promoted.
You were there for 9 years. Well, you say between 2002 and March 2011. I counted.
Yes, yes.
Right.
That's correct.
And you decided to start your own practice.
Yes, I started my own practice where I dealt with some commercial work. I still remember I used to do contracts for companies that had businesses in some African countries like Zambia and and Lusaka. So I was busy with commercial contracts during that time.
And where did you open this office? In Cape Town?
In Cape Town, I practiced from home at that
Alright.
time, yeah.
You're very brave, I must say. When I was offered an opportunity to work there, I couldn't wait to run away and go back home.
Not everybody can withstand what is happening in the Western Cape.
Yeah. All right. Your life as a solo practitioner was short-lived because you started acting.
Yes. I thought I was going to practice for quite some time, but the former JP said I must stay on until I was appointed. I thought I was breaking away from government now to start my legal practice, but it never ended like that.
Yeah. I see that you started acting as a judge in April 2011 and you never went back.
Yes. I only went back during recess.
All right.
My practice.
And you were permanently appointed in 2013.
In February.
You've acted at the SCA as well.
Yes.
So when?
Between June
The third
and
term?
September this year.
All right. It was just for that one term.
Yeah.
How did you find that experience?
No, the experience was fulfilling. Things are done much different from the High Court. And I must say I've learned a lot to take back to the High Court.
Yeah.
And also things that we thought were correct, that we should correct at the High Court level.
I see that you've done a lot of things. You've served in various committees and,
Yes.
and boards, in addition to running your own practice. So
Yes.
administration work you're familiar with
I've
it.
done a lot of administration work. It's only at the High Court that I was never given an opportunity to do that.
Yeah, I was going to ask about that. I take it you are one of the most senior judges in your division.
There are senior judges before me.
Yeah, no, I understand that, but you are not low level. You are
No, I'm
somewhere
not
up
low
there.
level. No, I'm not low level.
Have you been given an opportunity to act in the leadership position
No.
pertinently as an acting deputy judge president?
I thought that was something that I was going to address later on,
Okay.
when I'm dealing with my vision, perhaps.
Okay, no, that's fine.
Yeah.
That's fine. All right. The professional bodies generally speak well. Your reviews are fair. The GCB says an assessment of your judgment shows that you understand legal concepts, including constitutional law.
Yes.
But then they mention a judgment of yours, they and the Law Society of South Africa, which you served at some stage.
Yes, I served at the LSSA.
Yes. They mention a judgment, is it Labuskachne against Commissioner
Bernard
Sars?
Labuskachne, yes.
which
I
was-
think I sent a response in as far as that is concerned.
Yeah. No, I just wanted to raise something with you about, I'm not concerned that you were overturned by the Constitutional Court. I mean, if any judge will claim that they have not been overturned on appeal at some stage. What I wanted to raise with you is a concern raised by the Law Society that you omitted to mention that judgment in your questionnaire.
I omitted to include it in my questionnaire because I was not aware of it.
You were
at the
not
time
aware of it.
I completed my questionnaire. Otherwise, I had nothing to hide.
Yes. All right. You mentioned the vision. I'm salivating. Let's hear this vision for your court.
Okay. Let me start by advising this commission that I was nominated to this position at the time when I was preparing to take my acting stint at the Supreme Court of Appeal. It came as a surprise to me, but I had to agree to serve because I'm already serving as a judge in any event. So I'm going to start by telling this commission why do I think I'm the right person for this position? I've prepared something in writing. I don't know whether...
You want to read it?
Yes, I would like to.
You may do that. I find that that saves time.
Yeah. After I had an opportunity to observe different leadership styles from different leaders that I served under, I'm convinced that mine is slightly different from others. Besides being a visionary and a strategic leader, I think transparency, holistic approach on matters, welcoming spirit, and inclusivity is key to successful leadership. I would classify myself as a born leader because I chased opportunities to lead throughout my young days up until now. From my teenage years at the University of Transkei, I saw myself with some few students establishing a student body that was called Students for Human Rights. During those years, this body did so well in conscientizing the broader community of the former Transkei region, in educating them about their basic human rights and their right to vote closer to the first democratic election in 1994. As young students, we undertook this task diligently, although we did not have any Bill of Rights at the time. Our source document that we used was the Universal Declaration of Human Rights that was adopted by the United Nations General Assembly on 10 December 1948. The establishment of that student body was a success, which prepared the less privileged adequately for our democracy. This initiative would not have been possible without the support of the Lawyers for Human Rights, and later on, funding came from the University of Transkei. Despite being the youngest in the group then, my thought leadership and transformational commitment was well embraced by all involved. Shortly after I obtained my degrees, I joined the Black Lawyers Association, which at the time did not have a student body in the former Transkei. I and my former colleagues, who were candidate attorneys at the time, were tasked with the formation of the BLA student chapter, as we were fresh from university and still had contacts on campus. This initiative was well received by students who aligned themselves with the BLA objectives. Regrettably, I had to leave Mthatha before its launch, as I received a work opportunity as a director at Prela Oosthuizen Incorporated in Cape Town. Once more, when I arrived in Cape Town, the culture was different to what I was used to in Mthatha. There was close to no organizational structure that I could identify or associate with. For instance, there were 2 or 3 people who identified themselves as members of the Black Lawyers Association, but there was no organizational structure in place. I remember after having a meeting with Advocate Dumisani Ntsebeza SC, who shared the same sentiments that we need to form a body, a structure of the PLA in the Western Cape. We decided that I will mobilize people who are interested to join the organization and put formal structures in place. In our first meeting, I still remember Advocate Ntsebeza was elected as a branch chairperson, and I was elected as a Secretary General. The organization grew slowly throughout the years, and when Advocate Ntsebeza relocated to Johannesburg, I led the organization as the branch chairperson. I grew in this organization and served the BLA at the NEC level on more than 1 term. To this day, I owe it to this organization for nurturing my leadership prowess. This is the organization that deployed me to various structures where I led at different leadership roles, like being a counselor at the Cape Law Society and the Law Society of South Africa. In addition, I served as a board member at the South African Board for Sheriffs, and which at that time we found it in disarray. However, by the end of our term as the board, all systems were in place, and I assisted in setting up its disciplinary department, and I chaired the disciplinary committee of the sheriffs. I must say I gained much leadership I gained much experience in leadership when I was at the state attorneys for those years, and also when I ran my practice as a solo practitioner, although I had somebody who was assisting me at the time. For these reasons, I would find no difficulty in giving a strategic and jurisprudential direction to the division. I must say that I've mentored many acting judges in my division in judgment writing and in case management. Some of them did exceptionally well under my guidance and have now been appointed permanently. I interact with my colleagues and staff in general pretty well. I'm forthright in my approach, and I'm also time conscious, and I'm not scared in getting my hands dirty. I can safely say that I classify myself as a diligent and hard worker who's not afraid to lead from the front. My interest in imparting skills to others is not only limited to the bench. I do talks on relevant topics to students, disadvantaged communities, government institutions, mostly during recess. Also, I still do the BLA, I still offer training at the BLA trial advocacy training during recess. I do this training to law students and to the legal practitioners. At this point, I must pause and say that I am a human being, and at times I would make mistakes. So this means that I'm not averse to criticisms if I make mistakes. I take kindly to constructive criticism and take it as an opportunity to correct my mistakes and appreciate and understand issues differently. Also, in times of disagreement and with my calm and strong demeanor, I'm able to diffuse tension or conflict quickly before it escalates to something uncontrollably. I always think that communication is key to any kind of relationship. Transparency in communication and collegiality is something that should always be fostered at all times, I believe. With all that said, I am available for this task as I possess relevant leadership qualities. The fact that I have not acted in this position should not be put at my doorstep, as the acting criteria in these positions is not clear. From where the Western Cape High Court is currently, it requires strategic and visionary leadership. And I'm mindful of the fact that this is a view I formed from being a judge in that division for a considerable number of years. Despite that being the case, I've stated that I have not acted in the management capacity in that court, as the criteria remains unclear. However, I must point out from the outset that the situation is not easy as one would see, or as it appears. There are serious dynamics at play in the Western Cape High Court. One might say, for instance, I would ensure that all the colleagues attend tea room, they go to judges' lunches, they attend judges' meetings, but I don't think that would be a solution for starters. So with that being said, I would like to share my 10-point plan. If appointed as JP, I would like to implement. First, number one, I would start with addressing relations. 2, visibility of the leader in the division, that is the judge president herself. Number 3, skewed patterns of allocation of work. 4, transparency in the allocation of circuit courts. 5, modernization of court and virtual hearings. 6, access to courts. 7, shortage of judges and tools of trade. 8, transparency in the appointment of acting judges. 9, efficiency in utilizing court time. And 10, maintenance of stakeholder relations, more especially in the lower courts. With regard to the relations, in an environment where trust relations between colleagues have broken down for years, in my view, it would assist to get an opinion from a specialized individual on workplace relations to first conduct an assessment and give us a report on what remedial measures need to be implemented. That's for starters, because as I'm sitting here, I don't know what is the problem in the Western Cape. Coupled with that is the perception that some colleagues, due to their backgrounds, perhaps not originating from the Western Cape, are not supposed to be judges in that court. I consider these first 2 critical issues as delicate and of utmost importance and cannot be simply ignored or be resolved by a relationship coach or a diversity training workshop in a one-day session. Perhaps those might be relevant at a later stage, but not now. We need to identify, we need to zoom in into the problem right now. However, on the other hand, I must point out that the situation is not that ominous. The Western Cape High Court prides itself with judges who are committed to their oath of office and are always hard at work. Whatever relationship issues that might be there, they have not affected the work output. In fact, this is the compliment that we always receive from colleagues from higher courts, that is from colleagues from the Supreme Court of Appeal and colleagues from the Constitutional Court. Number 2, I'm going to deal with the visibility of the judge president. As I've stated earlier, in a division that has trust issues, it is my opinion that there should be visible leadership. What makes relations to be strained is that judges are reluctant to open up. For that trust to be regained, for starters, the lines of communication with the management should be open and clear. Having identified these areas of concern, once communication lines are open, it is my strong view that judges would have confidence in their leader. For instance, judges sometimes do experience work and personal challenges while executing their duties. For instance, if a judge approaches a judge president for whatever reason that might be there or concern, such conversation should remain between the two. Confidence is of utmost importance and should be key. One other example, if an email is sent to the judge president, that email should be responded to promptly. It is the role of the judge president to administer the day-to-day affairs of the division efficiently, and that invariably includes issues that are delicate enough and should not be responded to by the judge president's registrar or secretary. I'm acutely aware that secretaries are there, or a secretary is there to support the office of the judge president. But there are issues that are sensitive, personal, and operational in nature that are not supposed to be addressed to the judge by a secretary. It is therefore my plan to recognize, acknowledge, and give consideration to my colleagues, stakeholders, litigants in general, should I get the nod. In order to gain and maintain confidence on my colleagues and the staff in general, I will implement an open door policy. More interaction in forging healthy relations in the form of discussing and sharing sessions, perhaps a sharing session that would be planned on a certain Friday afternoon, sharing sessions on new judgments at least once per month, a reinstatement of judges' lunches. I don't know whether judges can afford judges' lunches given the fact that, given the state of their salaries currently. Also, judges' meeting and end-of-year functions would at least help to mend the relations in the division, because there would be that ongoing type of an interaction. I will also ensure that the information from other structures like the PEEC, heads of court meetings, the OCJ, that affects the division is reported back to the judges for discussion and resolutions to be taken as a collective. I'm now going to go to the third point, equitable allocation of work. For quite some time now, there has been a discontentment in how the work is allocated in our division. By way of an example, most permanent judges are working between unopposed motion court and criminal court currently. Matters of substance, especially civil matters and high-profile matters, are allocated only to selected few permanent judges, and on ad hoc or pro bono acting judges, or acting judges who are appointed from the ranks of the advocates profession. For instance, certain judges have been privileged to be allocated cases that enhances and develop the jurisprudence, whereas others receive none of that sort. I'm fully aware that perhaps that might be a strategy on the part of the management to address the issue of the backlog. But it is my strong view that expertise and experience of permanent judges, in my view, is not something that is normally taken into consideration when work allocation in both criminal and civil matters is done. Coincidentally, this does nothing to recognize the divergent skills that are possessed by the members of the court, I mean permanent judges. So permanent judges remain in criminal court for years. This by no means should be taken as downplaying the criminal court work or trivializing the work of some judges over the others. However, the truth is that the jurisprudential strong points of permanent judges should be recognized and nurtured throughout their careers at the bench. In future, this would create a pool from which the Supreme Court of Appeal and the Constitutional Court could draw acting judges from. I'm mindful of the fact that we still have backlogs, and backlogs are still going to remain with us for quite some time. At the same time, the reduction of case backlog cannot be addressed by removing permanent judges for about 3 years from the civil pool. Some sort of balance in my view, should always be maintained. This is not only detrimental to the judges who lose touch completely with that area of law, also it causes difficulty to advocates who deal with these voluminous and complex matters. For instance, when they revert back to their practices at the end of their stints, it causes delays with the handing down of the judgments, as they have to juggle between successfully operating their practices and or working on their reserved judgments. In my view, to ensure that permanent judges are upskilled and an expertise is created amongst its rank, if appointed, I'll ensure that an equitable distribution of work amongst colleagues is maintained. The uneven allocation of work should not be a weapon to settle scores and or to stifle the growth of others on the bench. In addition, when a motion court is allocated to certain duty judges, it should be finalized by the said duty judges and not be reallocated to judges who are not part of that duty. By so doing, a perception would be created that other judges are favored and or are shielded from heavy lifting. I'm now going to deal with my fourth point, transparency in allocation of circuit courts. Previously, when I joined the bench, the allocation of circuit court was done by order of seniority. However, lately there seems to be no criteria at all on how they are allocated. Some senior judges monopolize certain circuit courts, and in some instances, junior judges are given preference over senior judges. I think also a clear criterion should be put in place to the fact that, for instance, a duty roster of judges due to go on circuit should be kept and updated at all times. No judge should go on circuit court on 2 consecutive terms, or for the whole year for that matter, as it's currently done. A judge should spend at least 1 term at circuit court and thereafter revert to the division. Should a matter or matters not be finalized on an allocated time, it should be transferred back to the court or be heard virtually and be finalized as soon as possible. Also, I found that there's a problem in as far as the current demarcation of circuit courts are concerned. Something needs to be done, or the circuit court demarcation needs to be relooked at. As in my view, some existing courts are not located where the people are, or where the people are concentrated. Judging from the way the amount of work is increasing, circuit courts should be designated for both civil and criminal work, and not only be criminal work orientated. By so doing, this would assist in bringing justice to the people. I'll deal now with modernization of courts and virtual hearings. This project was first touted even before COVID-19 hit the world. However, its rollout has happened at a snail pace. And I understand that training by Mlambo JP happened for the first time in our division a month ago. And even then, I don't think that was enough to upskill the full complement in the division. Some ongoing training on case lines and virtual courts needs to be done. As a proponent of an online court and one of the first judges that received training on virtual platforms when COVID-19 hit, I think virtual hearings are the most efficient way in finalizing cases expeditiously. I know Mlambo JP has always offered his services insofar as the JP has already offered his services insofar as training is concerned. But this new innovation has not, in my view, received the embrace it deserves. In my observation, the older judges are not keen in learning new ways of doing things. Should I be offered this opportunity to lead the division, I'll ensure that filing online and reverting back to virtual hearings is introduced gradually or incrementally so as not to overwhelm those who are not keen on trying new things. In fact, it should be introduced in such a way that all would buy to it. For instance, virtual hearings have proved to be quicker and efficient in urgent matters, more especially in after-hours duties and unopposed motions. This is by no means evidence that open court should be done away with. However, this innovation will need support from the Office of the Chief Justice. I must stress that if judges do not have functional laptops and they do not have access to a stable network, or for instance, OCJ pays limited amount of time when making subscriptions or buying licenses from service providers to access the network, this strategy would be a futile exercise. I'll now deal with the access to court. Section 34 of the Constitution guarantees access to courts to all. There is a perception out there that courts are only accessed by those with deep pockets. This is evident on the caliber or types of litigants that we encounter in our courts on a daily basis. Even though the Legal Aid Board had previously broadened their scope in terms of matters it covers, it also faces some challenges in the sense that their budget has been cut. That will also curtail a number of underprivileged litigants from accessing, more especially the High Court. Coupled with this is the geographical location of the High Court. For instance, the Western Cape High Court is not easily accessible from the people who are coming from the most disadvantaged locations or backgrounds. And in my view, this remains a huge challenge. The lack of means is evident when one deals with the unopposed motions or a criminal trial. It is either that the litigants or witnesses come late to court because of challenges with the transport and find out that their matters have already been dealt with, or do not come to court at all because of the reasons related to shortages of funds. In my view, this problem could be partly addressed if, for instance, a criminal matter originates from Khayelitsha and the accused and witnesses are all from that area. An ad hoc circuit court could be created in Khayelitsha Magistrates Court to deal with such matters so as to eliminate the strain of traveling on those persons. This would only be a temporal measure until the location of circuit court in our jurisdiction is revised, as I've pointed out earlier on. I recently understood that, for instance, for legal practitioners licensed to be renewed with the LPC, that is Legal Practice Council, they are compelled to have done a stipulated number of pro bono work at a certain period of time. If the Legal Practice Council, as a stakeholder, could share a list of practitioners who have not done the number of hours, a judge on duty, for instance, could refer unrepresented litigants to these or to those attorneys. The Cape Bar also used to have a pro bono advocate readily available in court. I'm not sure whether that is still the case. It is my strong view that legal services and access to courts should be open and accessible to all citizens of this country. I'll now deal with the shortage of judges and tools of trade. The reason why we have this constant backlog is that currently there is a shortage of judges. That has been underscored by various judges from various divisions. I've heard this time and time again. This problem has been there even before I joined the bench as a judge. It is not clear whether this situation will remain or change would happen at some point. It is not even clear whether judges should get used to working under these pressurized conditions, as the situation cannot be changed. As a result, most judges end up getting sick due to stress they encounter on a daily basis. Let's take, for example, if the Western Cape High Court is allocated 6 to 10 judges tomorrow. Do we have space to accommodate them in the form of chambers, court, and staff? Not at all. The courts around the country in general seems to be carrying more challenges than solutions. This at that. Judges do not have updated law reports in their chambers. They even find login challenges to their online platforms that OCJ has subscribed on, that is LexisNexis and Twitter. This poses even greater challenges with the limited staff complement of legal researchers. Most daunting, I'm now speaking for myself. I have been standing on the queue for the past 3 years for a new laptop that has forever been promised that is on its way. I would at this point implore the Office of the Chief Justice to ensure that at least judges are provided with the basic tools of trade to ensure that they function optimally. The strain is even more if judges have to be burdened with the lack of resources to do their work. Even if there are austerity measures in place, judges deserve to be provided with tools of trade to deliver on their obligations as mandated by the norms and standards. Next point, transparency in the appointment of acting judges. It has always been said that the current process of appointing acting judges is shrouded, susceptible to abuse and patronage. I'm not sure whether that is correct. However, I'm acutely aware that the former Minister of Justice, that is Justice Ronald Lamula, introduced a policy to ensure transparency and fairness in the appointment of acting judges. Despite this be the case, it is my view that all the members of the legal profession should be given a fair opportunity to put their skills into test. It cannot be that the same faces show up all the time when calls are made for acting judges. In fact, should I be appointed, I think a committee should be put in place that is chaired by the Judge President to screen and identify potential candidates in the broader legal profession in line with transformation initiatives to act as judges. On the one hand, I would ensure that senior judges who are eager to train and mentor acting judges are identified for the success of the division in retaining skills, as more judges who are experienced have now retired. next point is strategy to utilize court time efficiently. In light of our backlog currently and shortage of judges, I intend to devise a strategy to use the court time efficiently. For example, counsel and legal practitioners should stick to the allocated time either by the court itself, or the time that they have reflected in their practice note. In so doing, allocations of 2 to 3 short matters per judge per day would be possible, should counsel stick to this allocated time. For instance, arguments should only be limited in issues of dispute. Counsel should not be allowed to read the whole heads of arguments, as the other parties would inadvertently have read the record timelessly. Also, in order not to put strain on the long list of reserve judgments and also to start the new term on a clean slate, I envisage the last week of term to be used to utilize by the judges to catch up with their reserve judgment and any other previously allocated work that remained unfinished to be finalized in that last week, so that when the new term starts, the court starts on a clean slate. My last point is the maintenance of relations with the stakeholders and magistrates' courts. I do understand that there is an ongoing relationship between the judge president and the stakeholders, and the stakeholder relations should be maintained at PEC level on an ongoing basis. We all understand that the coordination of all judicial functions of Magistrates' Court fall within the jurisdiction of the High Court, and it is the responsibility of the judge president to coordinate those relations. Also, I'm mindful of the fact that Magistrates' Court, they operate under enormous pressure to dispense justice at an entry level of the judiciary. In my preparation for this interview, I stumbled across a report that was prepared by the Public Protector, dated 4th June 2024. So in the interest of time, I won't really go through what the Public Protector identified as problems. It seems that the problems are all the same, in that the Public Protector identified that there is a shortage of resources at the Magistrates' Court, and it seems also issues with regard to domestic violence are not taken care of by the magistrates, and also magistrates themselves have reported that they've been victims of sexual harassment by their colleagues. And this is about 16% of women magistrates who voiced that opinion. So if magistrates have been victims of gender violence, victims of GBV, gender-based violence themselves, how are they going to make sure? Let me start by saying, if the women magistrates have been victims of gender-based violence, without any intervention in the form of counseling being done to them, are they going to be able to do justice to the cases that come before them? Also, if the male magistrates are found to be the perpetrators of this gender-based violence, that is sexual harassment, are they going to do justice to the matters that come before them involving sexual harassment? That is my, my question. Another problem that was identified by the public protector was the issue of bribery and corruption, but that one, she didn't have any mandate or capacity to investigate because it's beyond her scope, it's criminal in nature. And also there's lack of security in the magistrates' court. So if I'm appointed as a judge president, I would make sure that I do interact with the lower court in order to see to it that I support them in as far as their challenges are concerned. The public protector in her report concluded that court infrastructure, resources and staff conditions are deteriorating and there needs to be some improvement. It is without a doubt that also the lower courts experience huge backlogs due to COVID-19. So what should be done in such matters? So it would assist to interact with the magistrates more to get a feel as to what is it that needs to be attended to as of priority. I would also make sure that I identify all these courts within my jurisdiction who suffer from these hardships and support them and see as to how we can better mitigate these challenges depending on the nature thereof. In conclusion, I must say that judging from the support and messages received from my colleagues and from the support staff of the Western Cape High Court, from last week up until this morning, I do enjoy support of the majority of them. And I would have no problem in working with any one of them. That's my presentation.
Thank you, Judge Mantame. Judge Gamble.
Thank you, CJ. Judge Mantame, amongst your litany of complaints was the question of the allocation of work. And did I understand you to say that there's an inequitable allocation of work, that some people are getting interesting cases and others not? Was that your complaint?
It's not only my complaint, it's the complaint that I've heard from many of my colleagues as well.
Well, I want to just have a look at Barnard Labuskachny again. That was a very complicated tax matter that was allocated to you.
Mm-hmm.
Am I correct? It was a problematic tax matter.
Perhaps it was problematic.
Yeah. It went to the Constitutional Court and judgment was delivered there in 2022, volume 5, which means towards the end of 2022. But you say you never knew that the case went to the Constitutional Court.
I didn't pick it up.
Have you since read the judgment?
I did.
Are you aware of the strident criticism of your approach in the judgment of Judge Rogers?
Yes, I did see the criticism. But
Are you
also,
aware?
I don't know whether you've read my judgment.
Beg your pardon?
I'm not aware whether you've read my judgment.
No, I'm asking about whether you read the judgment of the Constitutional Court, which criticized you for your failure to apply one of the basic rules of our law, that's stare decisis.
Yes.
And that you ignored precedent.
Yes, I've seen that criticism.
And do you understand the criticism?
Yep.
Then there's further criticism. I'm simply looking at what the GCB had to say. There's further criticism that you dismissed a constitutional challenge which was made in the alternative without even considering it. Are you aware of that?
Yes, I'm aware of it. That's why I was asking if did you at least have a look at my judgment before?
No, I didn't. I'm asking you about the criticism of the Constitution.
In my judgment, I said that matter was capable of being determined without reaching a constitutional point.
On the issue of circuit courts, you suggest that there's an inequitable distribution of circuit courts. But you know that...
Not inequitable as such, it needs a revision because
Judge
it doesn't...
Judge Mantame, maybe I just ask you to be patient with Judge Gamble as we have been patient with you.
Okay.
Let him finish his questions,
Thank you,
please.
Chief Justice.
Circuit courts in our division are advertised at the beginning or the end of every term. Sorry, at the beginning of the term, the circuit courts for the next term are advertised. And colleagues are invited to apply.
Sorry?
Circuit courts are advertised. So, for instance, now at the beginning of this term, the circuit courts for the beginning of next year, the first term in January, first term in 2025, they will be advertised and colleagues apply.
I've applied, but I've never been given a chance to go to circuit court.
But they are advertised. It's not a
They are
question of them just
advertised.
being dished out.
But if you put your name down, you would be told that someone has taken it. Much more junior than you.
You speak about promotion of collegiality, and you speak about promoting that culture in the tea room. When last did you attend the tea room in the High Court?
I can't remember.
You at one stage were working from home quite a lot. Do you spend all of your time at the Cape High Court, or do you still work from home?
When was that?
Beg your pardon?
When was that I was working from home?
No, I'm asking. A number of colleagues during COVID and after COVID worked from home. I'm simply asking, do you spend all of your time at the Cape High Court, or do you still work from home?
I don't know how to respond to that question because I'm not sure which period are you asking for. I can't just respond without knowing which period I'm referring to, whether it was during COVID or after everybody went back to the building.
No, post-COVID.
I went to the building when everybody went back to the building.
And then lastly, you appreciate, Judge Mantame, that if you get the job, you inherit a deputy judge president who's already there and who is going to be there on her reckoning for at least another 5 years. You will inherit a judge president in the person of Judge Goliath. You appreciate that?
I do.
Will you be able to work with her?
I think so. I don't have any problems with
You
the
see, well, the
acting
reason
judge president currently.
The reason I'm asking is because I recall a judges' meeting not too long ago when you accused her of dishonesty in the face of other judges in an open meeting. You know the meeting I'm talking about.
I didn't accuse her of dishonesty. I still remember you intervened and you asked her to investigate the matter. And the matter, I don't think it was really investigated to start with.
Well, maybe our recollections are different, but I do recall that there was...
It was investigated, but the outcome was the same as what happened at the meeting, if you want me to put it like that. That's why I'm saying I don't think it was investigated, because we filed statements as to how the issues turned out, but I don't think those issues were even taken into consideration by the AJP.
But you say notwithstanding that interaction, you would have no difficulty in working with her?
Not at all. I do go to her chambers every now and then when I've got a problem.
Thank you, Chief Justice.
Thank you, Judge Gamble. I allowed you to continue with your questioning, but the thing is we don't know what you're talking about. And practice in this body is that if you are going to raise an issue of concern with a candidate, you forewarn them and this body so that they have a chance to respond, and this body has a chance to determine if that objection has any legs. It should be allowed. But then you wouldn't know. That's why I gave you leeway.
Yes, my apologies, Chief Justice. I was responding to the statement of the intent that the judge put forward. Okay. I was responding to the issues that she raised in her statement of intent.
Yes. All right.
But my apologies for overstepping the mark.
No, that's fine. Mr. Boshoff?
Thank you, Chief Justice. afternoon, Judge Mantame.
Good afternoon, Commissioner.
Just on the Labuskaghni judgment, I note your reply that you said, look, you weren't aware of it at the time of your application. But that judgment was handed down more than 2 years ago. So would you agree that given your position as a judge and the expectation, I suppose, from people who appear before you and the general public that judges know the law, that there's an expectation that you keep yourself abreast of developments in the legal landscape, and especially when it comes to judgments of the higher courts?
Yes, I do agree.
And especially given their binding nature on the lower courts.
Yes.
So does your explanation not admit to shortcoming in that regard?
Not at all, because sometimes you get to know about your own judgment when you're researching a certain point, when you're preparing a judgment. You don't always follow up on each and every matter that you've granted leave to appeal on. Once the matter leaves your desk, there are so many things, or there are so many matters that a judge should attend to at the High Court. The work is moving very fast.
No, sure. I take the point. I think my point is rather that regardless of whether you actively follow up on your own judgments, there are services in which the various courts circulate judgments on a daily basis to those who subscribe to them. So it's very accessible, especially with SAFLI being open source facility. What I'm saying is that in the normal course of familiarizing yourself with the latest judgments of the higher courts, you should have come across this judgment and said, hey, wait, but that looks familiar. I remember that case. And what I'm saying is your explanation perhaps reveals a shortcoming in that regard in the general continuous updating of yourself with the developments in the law.
Yes, I do update myself in the development of the law. I check all the cases that are delivered, for instance, by the Supreme Court of Appeal and by the Concord. Only if those matters are reported. I don't know whether this matter was a reported judgment, but I didn't pick up that it was a reported judgment. Hence, it skipped my mind, or it skipped my day-to-day looking at the recent decisions that have been delivered by higher courts.
Okay. Thank you, Judge. Thank you, CJ.
Commissioner Malem?
Thank you very much, CJ. I just want to ask you 2 questions quickly, and then I will tell you why I'm asking those questions. What is your understanding of a judicial temperament?
Judicial temperament. It requires that a judge should be able to listen and take into consideration other people's views and be collegial to others, and not act outside of what is required of a judge.
What is your understanding of collegiality?
Is that colleagues should be should have relations, good relations, and should be able to work well with others.
So when I walked in here, the CJ was still conducting the interview, and the way you were responding to her, at the beginning I thought maybe the CJ explained your relations before I came in, and maybe you know each other from somewhere else, because you kept on interjecting her and not allowing her to finish her points. And I was like, does she have a problem with her or what? But you do that to your colleague again, this side. And this time you don't do to her. You're doing to your colleague. She says to you, no, wait, until he has finished his point. But that's what we've been doing to her. Do you define that? You are the one who just said to me now, judicial temperament means that you must listen to others. But here you have to be stopped for you to listen to others. Interject the most highest office when it interviews you. Is that a true reflection of judicial temperament and collegiality at this level in public?
Commissioner Malema, I didn't see that as an interjection. I thought the Chief Justice had finished her questions, and I thought Commissioner Gamble had finished his questions. If I have interjected, I do apologize. It was not my intention to interject.
Thank you, CJ.
Thank you, Commissioner Malem. Commissioner Maimang?
Thank you, CJ. Good afternoon, Judge Mantame.
Good afternoon, Commissioner.
It's just one from my side. You did mention that it's easy for you to interact with the acting judge president upon the question that was posed by Judge Campbell. So now the question that I want to pose is, given the key areas that you have raised as part of your vision and with the relationship that you have painted around the dire situation of permanent judges in terms of circuit courts, the question that I want to pose is, I get an impression that, if you will tell me if I'm not correct, I get an impression that there is no platform by judges to raise these key areas that you have highlighted as problematic areas that has to be fixed, that are captured as part of your vision going forward. Is my impression correct?
You might be correct, Commissioner, because I raised them with the AJP and I raised them with the ADJP.
And I
But
guess you are not the
nothing
only one that have raised them. And in the meetings that are not minuted, but notes are taken, I guess that all these issues were raised in those meetings.
Not in a meeting. I raised them via email or verbally sometimes.
Thank you, Judge Mantame. Thank you, CJ.
Commissioner Mangena?
Good afternoon. Good evening, Judge Mantame.
Good evening, Commissioner.
Yes. Earlier on, we were told that the fallout between the then JP and the current AJP had actually led to serious problems in the division. And those would be some of the things that you would then need to deal with should you be appointed to this position. But then the question that I would want to ask you in relation to skewed allocation and second allocation, do you think that there are judges that are being favored as a result of the positions that they've taken in relation to the fallout between the then JP and the current AJP?
The short answer would be yes, I think so.
So there are divisions in the division?
I'm not sure about the divisions in the division, but there are critical issues in the division.
Thank you, Chief Justice.
May follow up just on this question. You say there are critical issues in the division. The first one that was highlighted, it would seem to me, is favoritism. Can you tell us what are these critical items? Because when you say they are critical issues, we don't know. What are they? What, according to you?
Commissioner Nokesi, I don't know whether I should talk about individuals in this commission that are being favored, or there's a perception that they are being favored. But there is that perception, without calling names.
Yeah, please don't mention names.
We may pass on from the question. In fact, no, we may pass on from question because my understanding was there is favoritism that one can't pass. And then I understand you to be saying there are critical issues, not necessarily that. I didn't understand that to be names. I was maybe thinking, what is this critical point issue? But now if we are not comfortable, we can pass on with that question.
Commissioner Steinberg?
Good evening, Judge Mantame.
Good evening, Commissioner.
I'm going back to the Labuskaghni judgment. When Judge Gamble asked you about the Constitutional Court judgment, you responded by saying, "Have you read my judgment?" And I have two questions in that regard. Are you implying that the Constitutional Court got it wrong and your judgment was right?
Not at all, Commissioner. What I wanted to clarify is that perhaps the case that was put at the Constitutional Court is not the case that I was confronted with, that's all.
Well, I'd like to probe that. The Constitutional Court said on the issue of the rescindability of tax judgments. It says that all the authorities which have said those are final judgments and are rescindable were brought to your attention, but you ignored them and didn't follow precedent. Now that seems to be correct from a reading of your judgment and the Constitutional Court's judgment. So what about that was not before you?
You would remember that Metcash dealt with the VAT, with the VAT Tax Act. The matter that was before me dealt with the Tax Administration Act. The Metcash was decided in 2000. The judgments that I relied on were provincial divisions that were recent, and some of them spoke on what was happening in that matter, that they referred to the Tax Act, to the TAA. So the Tax Act TAA, in my view, was addressed more better in the recent judgments of the provincial division, in the judgments of the provincial divisions, than what was at play in the Metcash. Remember, Metcash didn't deal with the rescindability of several judgments. The Concord in that matter dealt with the declaration of sections of the VAT Act unconstitutional.
Well, the court here also comments that you didn't explain that. You didn't actually distinguish. You didn't take into account a whole lot of authority, and you didn't explain what you've just explained now, which I think is correct.
Yeah. That's why I said I do accept that criticism. Sorry.
No, carry on.
Because my judgment was not thumbsucked, it came from precedents from the provincial division.
My second question also relates to your answer to Judge Gamble. And following on from Commissioner Malema, when he asked you about the Constitutional Court judgment and you said, well, have you read mine? Do you think that displays collegiality and an appropriate judicial temperament?
I thought by asking that question, it was going to have a balance on what was before me and what was dealt with by the Constitutional Court. I didn't in any manner try to disrespect Judge Gamble. Thank you.
Follow up, CJ. Good afternoon, Judge. I'm here.
Good afternoon, Commissioner.
Yes, I just want to follow up on the Labuskagni judgment. My understanding of that judgment, first and foremost, Rogers J was not conclusive in his statement. He said you appear to have not relied on precedent. That's the first point. He was not conclusive about the issue. But that's not the point. He actually referred to a judgment of the Supreme Court of Appeal, or the Appellate Division, the 1973 Appellate Division case, the Kruger case. And in his reasoning, he says that, in fact, in that particular case, the Appellate Division stated it categorically that tax judgments were rescindable. And that is the basis upon which the criticism is based. I'm not sure, do you have any comment on that?
I've seen the judgment that it started analyzing judgments from 1965. Those judgments were not before me when the matter was argued. It was only Met Cash that was put before me.
But was the issue whether a tax judgment can be rescinded an issue before you?
Yes.
But surely that is an issue that can be researched. It might be that the parties themselves, or none of them, actually argue the case before you. But I think if there is authority from a higher court, then one would expect that at least that authority is located, unless perhaps there's a challenge with resources in terms of research and so forth. And I think that's where Rogers J was coming from.
Commissioner, the reason, perhaps maybe I might have appeared hostile in asking whether Judge Gamble read my judgment. The case that was before me was not clear to start with from the applicants. The applicants didn't know which instrument to rely on. Firstly, it was said the application is brought in terms of Uniform Rule 32 to capital B. There's no uniform rule dealing with the rescindability of judgments in as far as that rule is concerned. Secondly, they said they brought the application in terms of Rule 42. Thirdly, they said they brought the application in terms of common law. I was confronted with those three legal instruments, and I had to analyze them all as to which one would be relevant in their case. It seems as if their case was all clear before the Constitutional Court. That's why I'm saying I don't know which case was put before the Constitutional Court, because the papers were in shambles when they came before me. But I do take that today the criticism is on me. It was not a good drafted application that I dealt with.
No, I can accept that. A case evolves with time, and sometimes when it gets to the Constitutional Court, it becomes better explained. I can accept that.
Sorry.
Thank you very much, CJ.
And even wrong legal instruments were quoted, and I had to probe during the hearing. Which Rule 32 are you referring to? Are you referring to 31(2) small b that deals with the...
No, thanks, Judge. I think you have made a point, and I think I agree with you. Thank you very much.
It was a bad case that I had to deal with, Mr. Commissioner.
Commissioner Ngaitot?
Yes, thank you, Chief Justice. Judge Mantame, I just want to come back to this point that you were discussing with Commissioner Steinberg on the Labuskagni judgment, because I'm very worried about the way you've characterized the criticism of the Constitutional Court, because it seems there's one issue that they take with your judgment, which is whether or not you were correct that a tax judgment is not final and therefore not rescindable. Do you accept that?
Yes, because that was my finding.
Yes. Now, on that issue, it doesn't matter whether they characterize it as a Rule 32 or any other rule, because it's a question of law. Now, what they say about what you did is that you failed to have regard to at least 3 judgments that were binding on the issue, despite the fact that those judgments had been brought to your attention. In fact, it's only in the leave to appeal where you referred to Metcash. And the way you did so, at paragraph 29 of the Constitutional Court judgment, you said that the Constitutional Court did not make a finding of law, it just made an observation. This is why they use very strong language to say that your judgment was unacceptable. It's because you poo-pooed, you dismissed, you waved away a binding authority that says a tax judgment is final. That's the criticism against you. In other words, you treated authority of the Constitutional Court as if it didn't exist. So you can find that in the judgment itself at paragraph 29. They come back to that at paragraph 30. They say the reasoning in Metcash, now they're responding to you, on rescindability was not merely an observation. It was an integral part of this court's reasoning. And Metcash, in turn, endorsed the 2 judgments in Kruger. So that gives us 3 that were brought to you. You don't apply them, despite the fact that the Concord has spoken authoritatively on the subject. Now, my concern is not so much whether you get the job of being JP. It is what you will do when you return as a judge, bearing in mind the posture you've adopted today about the authority of the Constitutional Court. Can you comment on that?
Commissioner Ngwaito, I'm not sure what attitude I've adopted about the Constitutional Court.
You've said it was a different case before the Concord to the case that was before you, whereas I've just pointed out to you it was exactly the same issue, which is finality of tax judgments. Now, once you don't accept that it was the same issue, my fear is that you will repeat the same error of treating with dismissiveness judgments of the Constitutional Court. If I can just finish this point, maybe then, paragraph 30 says, observance of the rules of precedent is not a display of politeness to a court of higher authority. It is a component of the rule of law, which is a founding value of the Constitution. My fear is that you will not follow precedent.
As I said earlier on, Commissioner Ngwaitobi, that I do accept the judgment of the Concord. I do accept that I'm bound by the judgment of the Constitutional Court. However, there was a lot that I had to unscramble in the court of first instance to reach the decision that I've reached. Maybe it didn't come out clear that I had to unscramble a lot of issues before I came to that conclusion. I did not at all, not in 1 minute, say that I'm not bound by the President of the Constitutional Court.
No, I don't think you said you were not bound, but the approach we've taken before us is that it's because the applicants failed to identify the issue and therefore the issues were different. So in other words, you still don't see that there was an error in your judgment because you got the law on finality of tax judgments wrong. And that's the point I was putting to you.
Commissioner Ngwaitobi, it's not that I didn't see what was in front of me. I was just giving a background as to what is it that I was confronted with. I thought that was going to clarify the issue as to why I came to the conclusion I came to. Not that I want to disrespect or disregard the judgment of the higher court, Apex Court for that matter.
Yes,
I wanted to give a background.
No, I understand that, but the issue is still the same. It's whether or not tax judgments are final. That's the issue before you, that's the issue before the Constitutional Court. So I'm struggling to understand why this background is relevant to that issue. And that's why I fear that you will just repeat the same error.
Commissioner Ngqwaitwe, I won't repeat that error. I'm committed to that.
Commissioner Shabangumdawe.
CJ, I'll let it pass. Thank you.
President Muleme.
Good afternoon, my sister Justice Mantame.
Good afternoon, President.
Yes, you confirmed that you acted at the Supreme Court of Appeal during the third term, so more or less for 3 months, correct?
I do confirm.
Yes,
President.
and I think you also stated that you learned a few positive things from that acting stint, correct?
Yes, that is correct.
Yes, I confirm that I think you were in my panel in 1 or 2 matters, if I'm not mistaken. Just to give you credit to say that I was satisfied with your level of participation in the conferences. You'll recall that we had a session with all the acting justices just before your term came to an end, and the parting shot was that request that all of you should go and plow back to the courts where you come from. Do you remember this?
I still remember that day.
Yes. Now, from your own personal experience, what is it that you will be able to plow back based on the experience that you got during your acting stint at the SCA?
On 2 occasions that I sat with another senior judge, there were problems in matters coming from my court where a full bench would sit as a court of first instance. So it caused some problems when it comes to leave to appeal. Parties, they don't know whether to ask for leave to appeal from the High Court or to ask for leave to appeal from the Supreme Court of Appeal. Mostly they approach the Supreme Court of Appeal, of which the Supreme Court of Appeal said it's wrong, they should go to the Court of First Instance. And that's one of the things that I would take back.
So if I understand you correctly, you are going to offer assistance to your colleagues?
Certainly, that perhaps those full benches are unwarranted in a situation where the court is going to be the court of first instance.
Thank you, Justice Mantame. Thanks, CJ.
Judge President Mlambo.
Thank you, CJ. Good afternoon, Judge Mantame. I'm here.
Good afternoon, Judge President.
Just 2 things from myself. One, I checked the last available reserve judgment reports. There were 2 judges in your court who were owing judgments. The period recorded was 22 months. And then there are others in varying time periods, up to 6 months, from 22 months, 18 months, 17 months, 16, up to about 6 months. If you are appointed as JP, how do you propose to help curb this problem?
Can I answer, Judge President?
Yes, please.
Firstly, I would identify as to what is the reason for the judgment to be reserved for such a long time. And if there are problems, I would see where could I assist. And also implore to the judge concerned that he or she should finish the judgment as soon as possible because of the norms and standards that we should stick to.
You know, the CJ, the outgone CJ Zondo, threatened JPs for not reporting judges who owe judgment. I don't hear you mention that.
I don't know whether they are not reported by the current management, or I should have put in my plan that I would report them. I'm not certain about your question.
Well, I think my question, this is a follow-up question. You said, I asked you what would you do to assist in terms of addressing this reserve judgment problems. So if you're appointed as JP and you have a judge, say your tracking system fails you and you discover after 12 months, you discover that there's a judge who owes a judgment for 12 months, what would you do?
Firstly, I wouldn't understand why the judge president has to leave the judgment up until it's 12 months old as a reserve judgment. Because I start panicking with my own judgments when 1 month passes. That time is ticking. Even on the second month, I think the judge president is supposed to impress upon the reserve judgments that they should be finalized. 12 months is way out of line. It's a matter that should have been reported to the Chief Justice at 6 months for that matter, as far as I'm concerned.
Yes. My last question to you is, it appears that it is a problem in the Western Cape Division in terms of the capacitation of the different roles. It looks like judges are more allocated towards criminal trials, especially when we hear this mention of backlogs, than to the civil part of the role. If you are appointed as JP, what strategy would you adopt to ensure that there's equitable distribution of judicial resources to ensure that no work area suffers because of lack of capacitation?
It is a fact that a continuous role at least should be maintained at all times. Judges who are in the civil pool should rotate and go to the criminal pool. It's inexcusable that there could be judges who stay longer in the criminal pool and don't have a feel of what it's like to be in the civil pool for years. Currently, judges carry about 2 to 3 matters, criminal matters at a go. So I don't think that is healthy, because I don't know whether it wants to imitate the way things are done at the magistrates' court. Magistrates' courts, they don't have continuous roles, for instance. You'll find that magistrates do 15 cases per day in the criminal courts. I don't want the High Court to be turned to be like magistrates in the future.
Thank you very much, Judge Mantame. Thanks, CJ.
Thank you very much, Judge Mantame. Sorry, it's been a long day. You're excused.
Thank you, Chief Justice, and thank you, Commissioners.